you taking the time to join us.
Morning, Stephanie.
So I do want to start with today's arraignments. These are on the state charges, including murder as a terrorist attack. We did hear that he pleaded not guilty to these charges. And what's interesting, Jeremy, is that typically, as you know, cameras are not allowed inside the courtroom. However, we were allowed to have some playback of some of the exchanges between the defense and the prosecution. And I have to imagine that this is because of the high profile nature and the public curiosity involved in this case.
You would think so. And what's interesting, too, was that the defense really took aim at the perp walk, the helicopter flying in, all the law enforcement that was there, and made it a point to say, hey, why's the mayor here? What's that guy have to do with any of these things? He's got his own legal problems. So maybe a bit of a deflection, but the defense very much made a point of the public nature of this case, how it's been so far, and basically sort of laying the groundwork for maybe a change of venue or something like that in the future. But yeah, I think you're right. I think that's exactly why we're able to see it on the replay.
So I want to ask you this because one of the state charges is murder as a terrorist attack, and this is a very serious charge. You know, how does this differ legally from the charge of murder? You know, obviously there's much more weight to it, but you share with us the legal difference between the two.
Okay, so when we're talking about comparing first-degree murder in New York to second-degree murder in New York, what you need is what you would call an aggravating factor to differentiate a second-degree homicide from a first-degree. It could be a hate motive. It could be some motive, like in this instance, terror. So that's going to be when we're comparing the state case to other state charges. That is why it's a little bit elevated. When we compare it with the federal case, and sort of what the lawyer was talking about was that there's a bit of a tension here. So the federal law is basically that you planned this, you premeditated it, you went across state lines, you did all these things that triggered the federal tripwires. However, New York is saying that you did this to incite a public outcry or a public fear, whatever that may be. Well, the federal government is basically not really saying that. They're saying, no, you did this individually. So the lawyer was kind of playing off some of the tension in between those two laws. So that's definitely something to keep an eye on.
Yeah, and meanwhile, Mangione is also facing federal charges that could bring the death penalty. We were hearing that both cases are going to be run parallel. So legally, how does that work?
The federal government, we have a dual sovereign system, right? We have the federal government in all 50 states, and then we have our state governments that are beneath that. And the supremacy clause says the feds basically get to pick and choose what they want to do. So the feds could, if they wanted, take priority here. They're not. They're basically saying, look, we're going to let New York State do what they want to do. They also have to get along with their law enforcement brethren, right? They have to live in the real world. They have to this is not the only case that has state and federal consequences in New York. They have on hundreds of cases, if not thousands of cases, they've got this overlap. So that it is an ongoing relationship. And here they've made it clear that the state charges are going to go first and that those are going to take priority.
So as we take a look at the two cases, one state, one federal, they're going to run parallel. When it comes to the strategy, the legal strategy of Mangione's attorneys, will they differ because of the charges and the nature of the charges that are different? Or do you imagine that the strategies would be quite similar in these two cases?
You have to win the game that's in front of you. It's just like football, right? You have to take the down and distance, and you have to worry about first things first. I would think that this case only gets tried one time. I think that you'll see a trial in New York State. I think if he is found guilty, there's probably a plea in the federal system. Probably. I don't know that for certain, obviously. But the first and foremost challenge for the defense is this New York State case. And in this New York State case, you can have a possible insanity defense. It looks like that may be the angle that they're sort of taking, that he didn't appreciate what he was doing was wrong, that this was a young man who 6 months ago, all of his friends, all of his family are saying we don't recognize him anymore. We don't understand him anymore. 2 weeks before this, there was a missing persons report put out there. And so you've got probably an easier time fighting a not guilty by reason of insanity than you do basically saying that wasn't me. Because all of the circumstantial in the case has really just sort of walled him in to that defense. The state court has a slightly easier road for not guilty by reason of insanity than the federal defense. And that could be a common thread if you're looking for one, right? Because there is a federal not guilty by reason of insanity, although it is harder. Fundamentally, Mangione and his lawyers have to win the case that's right in front of them. And at the moment, it looks like it's the New York State case.
So when it comes to that, though, he just entered a not guilty plea in court today. If they change their strategy and they want to change his plea to not guilty by reason of insanity, when do they have to make that change?
It's going to be triggered by their trial date, and he will have to give the prosecution notice within a certain amount before that trial date. Not guilty by reason of insanity is a defense that does require prior notice to the other side. Most criminal cases don't require the types of notice of how you're going to defend a case, right? If it's for, say, you're going to say it wasn't me, it was him. Or if you're going to say this case, there was a reasonable doubt here, right? You looked at Donald Trump's Manhattan trial. He and his team didn't have to tell the prosecutor what they were going to do before they did it. They just did it. They didn't have to say, well, here's how we're going to defend this case. We're going to blame Michael Cohen for this. We're going to do this. We're going to do that. You don't have to do that. It's different in a not guilty by reason of insanity because it involves so much science. The burden actually shifts to Mangione and his team. They have to prove beyond a preponderance of the evidence that he did not know what he was doing was wrong at the time that the offense was committed. And then the prosecution will have the ability to try to have their own expert witnesses who can sort of combat that. And it takes time for those types of experts, those types of forensic psychologists and psychiatrists to really review all the data. That's why you just can't show up the day of court and say, surprise, this is going to be our defense. That's why they get so much advance notice here.
You mentioned earlier, a possibility of change of venue, and they were mentioning the New York City Mayor Eric Adams, walking behind as, there were cameras. This was quite a high-profile walk, if you will, from the helicopter. It's very unusual in nature. So the arraignments have happened. We now know that he's scheduled to appear in court next in February. So between now and then, legally and strategically from both sides, what might we expect?
The defense today invoked their right for what's called an expedited discovery in New York State. And because Mr. Mangione is in custody, that means that the prosecution has to give the defense within 20 days all of what's called the discovery. That's going to be police reports, search warrants, evidence and lab analysis that they got from those search warrants, any type of body cameras that are worn by law enforcement. It's a bit of a task to do, and you would think that the authorities in New York State and the prosecution in New York State, you would think that they anticipated this, and hopefully they're ready to go. They've already given a lot of this evidence, showed it a lot of it to the grand jury, so you would think that they've got it compiled in a way to where they can give it over to the defense. Now, the defense is just being aggressive here because, again, does it make a big difference if you get all this information within 20 days or 30 days or 40 days? I mean, they're going to have a little more time to prepare for trial than just that. More than anything, Ms. Agnifilo is just sort of showing the prosecution that she means to be really aggressive here.
So, Jeremy, as we continue to take a look at this case that has just rapidly developed over the last few weeks or so, legally, what are you keeping a very close eye on? Or, as it stands now, anything that really has drawn your attention or perhaps your surprise?
The most fascinating thing to me has been to see if the defense and how it is sort of evolving, and are they going to go towards not guilty by reason of insanity? Again, if I'm defending this case, I'm looking at three things, right? There's the it wasn't me defense. right? Which you don't have to legally have an alibi, but it really helps. And we've just not seen any evidence of that, right? Also, you've got all this circumstantial evidence that is sort of walling him in and walling him in and walling him in. That's one way to defend the case. Another way to defend a case is to say there's a reasonable doubt defense. Ladies and gentlemen of the jury, there's a reasonable doubt about this evidence. And to do that, you have to attack search warrants. You have to attack evidence. You have to attack lab analysis. And that is a very, very hard thing to do. So the first two options are very low percentage. That leaves not guilty by reason of insanity as kind of your only one that might actually come close to working in a case like this. But again, you're going to need to have a forensic psychologist or psychiatrist visit with Mr. Mangione, potentially multiple of them. You're going to have to go throughout his life history, his recent history, maybe even his family history, because mental illness can certainly be hereditary. And it's going to take some time for that to sort of build up. So that's what I'm looking for. Is that where the defense is going in this case? And look, this murder happened in December. That's something that I think we all sort of lose sight of. Is that this is a very recent situation, and we are this is so rapidly developing. But looking forward at it, that's sort of where my mind is.
It's going to be very interesting to continue as we analyze and take a look at all of these developments. Jeremy, as you said, this is just a rapidly developing case, unusual in many respects, including the timeline and also just the scrutiny and the tension that all of this has gotten. We appreciate you joining us here on Live Now from Fox to talk about this breaking news.
Thank you very much. Have a great morning.
You too.